Good morning, everyone. So today's chapter is going to be on copyrights, another very important intellectual property of individuals, of companies, of e-businesses, of teams of people who have ownership of proprietary intellectual capital. So copyrights is definitely an intellectual capital that has to be protected. We all are aware that these are very important things that individuals or institutions or organizations want to protect. So having said that, we'll just move on to the slides about what are copyrights. So as I just mentioned, it's a form of intellectual property, along with other intellectual properties such as trademarks, patents that we discussed last class, trade secrets. Copyrights are again a very important intellectual property. They are legally, you should be protected from all kinds of threats that you might have, people trying to steal your original work, and it could be authorship. Anything that is available in a tangible medium of expression is known to be copyright protected. It can be copyright protected so that you don't have someone use that without your permission. Not just original works of authorship, like suppose if I'm a professor, I published a research paper, I'm an original author, I have a copyright towards my work, and nobody else can use that copyrighted work unless they seek permission or they give a proper appropriate citation. Not just that, computer software and architecture, any code that you have written, which is very unique, very special, in that sense can be protected by copyright protection as well. Movies, other audiovisual works, including those, on the website, those are all, intellectual property that can be protected. Musical compositions, lyrics of his song, nobody can reproduce it or sell it without your appropriate permissions and approvals. Novels, ebooks that we might have written, poetry, all these things are extremely important as intellectual property. They all get the copyright protection by filing the right set of documentation with the Copyrights Office. Any literary work, including website content, that's why you're in this class, and you're going to have e-businesses. You'll have anything to do with e-commerce. You might create your own web pages, very unique design, unique layout, a specific type of interactive websites that you are creating, all creating a great experience for customers. These are all possible to be copyright protected, or else somebody's going to steal your work. Dramatic work, sound recordings, including website audio transmissions, pantomimes, choreographic works, sculptural work, architectural work, are all intellectual property that require copyright protection, and nobody can be allowed to use it without the proper authorization. Now, common law provides the author of any kind of original and creative work with copyright protection as soon as it is in a fixed and in a tangible form. It has to be in a tangible form. So obviously, when I'm working on a research paper, I'm giving my example. If I'm working on a research paper, it's not yet in a tangible form. It's just an ideation. It's something that we are still discussing. Now, that cannot be copyright protected because I'm still discussing it. There's nothing that has been written in a tangible form. It's nothing that's been recorded in a tangible form. So the very important thing that you can remember is that any copyright protection is possible for any original and creative work once it is fixed in some tangible form. In my case, if it is fixed in a Word document I've started writing, and now these ideas are fixed in a tangible form, they can be copyright protected by filing the right set of papers, getting the registration done, and U.S. Copyrights Office can issue me a certificate of registration for my work. So we have to initiate that legal claim for copyright infringement in the federal court systems, and by filing the appropriate paperwork at the U.S. Copyright Office. That's an important thing that you have to do so that you get the protection. And if you file the proper paperwork with U.S. Copyrights Office, because it's now in tangible form, it's a piece of original work, it's pretty creative, it's your own work, they'll issue you a registration of copyright, and then it belongs to you. Now you're the owner of that very original work, that creative work. So initiating that legal claim doing the paperwork is an important first step if you have done anything. It's not about research paper, which I was just mentioning. It's about movies, it's about music, it's about novels, ebooks, any poetry that you've been working on, dramatic work, sound recordings, any literary work, sculptural work, any new piece of architecture, especially if you're an architect and you're creating a new design, which is, say, energy efficient, which actually is great in terms of energy consumption, reducing the energy consumed. Any kind of such work can be copyright protected. Now, copyright law is a federal law, and it's found in the Copyright Act in the US that protects these authors from copyright infringement for original works of authorship, anything that's fixed in a tangible medium or of expression. So the Copyright Act actually governs everything that is to do with copyright infringement, and anything that's original piece of work, any creative work in a tangible form can be protected by filing the right set of papers. One of the first orders of business of any e-business should be to file for federal copyright registration of its web pages. Now, you also are aware that almost all businesses today, whatever products or services they're selling, they have online presence. They have web pages because that just allows you to sell your products and make your services available across the globe. Technology is enabled to do so many things, and you all realize that every business wants to have an online presence, an e-business presence. And that's why one of the most important things that you must have at the back of your mind is when you create a business and you're making an online presence, you want to file for federal copyright registration of your web pages so that nobody uses the same colors, the same layout, the same interactive patterns. Now, web pages definitely are original works of authorship. They satisfy the statutory requirement that it has to be fixed in a tangible medium of expression. In this case, they are in a tangible form using technology where you created the web pages themselves. Because designing, producing, and maintaining a sophisticated website is pretty expensive. We all know that. And protecting content ownership is extremely important. So if you create your own, e-commerce web page where you're, selling products, and if you lay it out like how Amazon has its web pages, that might be a real problem. It's an infringement of copyrights that Amazon has in the choice of colors, their layout, and the interactive options that Amazon has. So those are important things that you have to keep at the back of your mind, that as a business owner, anything to do with creating your own web pages, having an online presence should be copyrighted so that somebody else is not going to use your web pages. As websites become more interactive, their creation, design, maintenance places enormous demands on innovative marketing techniques that should be legally protected. The more creative your web pages are, the more interactive your web pages are, the more pains and investments and money and time and effort you put in designing your web pages, it becomes even more important that you have the copyright protection and nobody else is actually infringing your copyrights. They're not copying and misusing your design, your layout of the website itself. And copyright law is a strict liability statute. This means that it's possible to be liable even if there is an unintentional infringer. And that's a very important aspect that you should remember when you're talking about copyright law. I cannot claim that I did not have an intention to infringe any copyright because copyright law is a very strict liability statute. This means it is possible to be liable even if you do not have an intention to infringe and you have indulged in some form of infringement, you will be punishable, you will be accountable, and a legal action can be taken against you. Hence, the importance of you as an e-business owner, you have to work closely with your lawyers and attorneys, and that importance cannot be overestimated. It's extremely important because copyright law is a strict liability statute. Now, e-businesses and copyright objectives and legal strategies. So if you have any kind of online presence, every organization today, even educational institutions like our university, has an online presence. And so there are objectives and legal strategies that any online e-business must be aware of and should take real care to protect themselves. So they have to protect the web pages of the company's website from being copied. It could be the colors, the branding, the logos, the design, the layout itself and the interactive options that you have. These things should be prevented from being copied. So you have to protect your web pages from being copied by other companies, and also protect the company from any copyright infringement. So somebody can also take a legal action against your company and accuse your company of copying someone else's web pages. So your objective is both ways. You have to protect against your web pages being copied without authorization. You also have to make sure you are not unintentionally copying someone else's website. So those are the objectives. So the legal strategy here is step first, register the copyright of the web pages. So file in the documentation. You get a copyright registration document from the Copyrights Office. And then therefore, your first thing first, you have to register. Include all the appropriate disclaimers in the terms of use for copyright infringement by linked companies. You're dealing with suppliers, you're dealing with vendors, you're dealing with a lot of external stakeholders. So any kind of disclaimers that must be there in the terms of use for the copyright infringement to any linked companies must be stated. You have to monitor bulletin boards and chat rooms for known copyright infringements by third parties. So you got to have people who are like watchdogs and are looking out if there is any kind of intentional or unintentional infringement of your web pages. So that's the legal strategy. You have a responsibility to protect yourself and also protect yourself against unintentional infringement of some other company's websites, because you don't want legal actions filed against your company. Now, what can be copyrighted are listed here. This is, again, not an exhaustive list, but it pretty much covers a lot of stuff that can be copyrighted. So literary works, musical work, any piece of music that's pretty original, pieces of drama and dramatic works, pantomimes, choreographic work, pictorial graphics, sculptural work, motion pictures, audiovisual work, sound recordings, architectural work, authorship of books and research articles. All of that can be copyrighted. And why should we not do it? Because we take pains to do it. It's an original piece of work. You don't want somebody to use your original piece of work, innovative, creative work, without appropriate citation or without appropriate permission to reuse it or sell it without your approval. In order for this material to be registered in the Copyright Office as a copyright, it must be an original work of authorship. So you cannot copyright something that's not original. It should be fixed in a tangible medium of expression. So any kind of open discussion is not copyrighted. So you've got to be careful of what you're talking, because you don't want your great ideas to be stolen before they are expressed in a tangible medium of expression for which they can be perceived, reproduced, or otherwise communicated. Anything that can be perceived, reproduced, or communicated directly or indirectly using machines or devices is what we call fixed in any tangible medium of expression. So it should be original. It can be fixed in a tangible medium of expression. It should be something that we can perceive or reproduce or communicate it using technology, using devices that we are aware of. So such a thing can be copyrighted. So criteria for copyright protection of a web page, which is again a little bit, one of the elements of those things that can be copyrighted. Originality. The website may not copy a similar site and should strive for a unique presentation. So it has to be original. If I'm just copying some other web page, I'm an infringer. I cannot ask for copyright protection because it's not original. Some other company that whom I'm copying can actually file legal action against my company because I'm an infringer. Creativity, the website needs to be novel, as in a patent requirement, but should be an independent creation. It should not resemble anything that is already existing out there. That's why they make a reference to patents. Fixed form, the application of the content to the website is sufficient to create a fixed form because it's there for us to see, for us to refer back, for us to visit the website. So it's there, it's in a fixed form right now. It's not just a discussion, but you actually see it. So these are the criteria for applying for copyright protection of a web page. It should be original, it should be creative, it should be novel basically, and it should be in a fixed form. Now, the requirements for registration in the Copyrights Office, you need to complete a registration form, submit the original piece of work because they have to verify if it's really original. And if there is any reference to anything that's already existing, they might deny you the copyrights. So the Copyright Office, then if they're happy with whatever original work you're submitting, they will do their own due diligence. And if they're happy, they'll give you the Copyright Office then issues to the owner, that's you, a certificate of registration. In a copyright infringement case, it becomes your responsibility to submit this certificate as a proof that you are the actual owner of this particular copyright. So if you have a web page and you have the certificate of registration, now you're complaining that I copied your web pages. It becomes your responsibility to produce that certificate of registration because you're filing the complaint, and that's why you're the plaintiff. It becomes your responsibility to submit the certificate of registration as a proof that you are the actual rightful owner of the copyright itself. And of course, you can still file a complaint against me. And if the legal authorities find that there is an infringement, then you have remedies for your complaint that you're putting across. The certificate is prima facie evidence of the validity of the copyright and allows you as the owner to sue an infringer like me in the federal court and pursue statutory remedies. So you can take me to the court because you're accusing me as a plaintiff that I've copied your web pages. You're showing the certificate as a prima facie evidence that you are the rightful owner, and then you're filing a complaint against me because you think that I'm infringing your web design. You can take me to the federal court, and based on the proceedings, you can pursue for statutory remedies, which we'll discuss in the following slides. Any questions so far? It sounds good. Duration of the copyright. This is an important slide for how many years do you have the ownership of the copyright. There's a lot of changes that have happened. I'll give you a historic perspective and of what is there right now. So in October 1998, the Congress enacted the Copyright Term Extension Act. It's called the CTEA. It extends the term of most copyrights by 20 years. So it makes sense. They did this because they wanted to make the changes so that the US law is in harmony. It harmonizes US law with European copyrights law. As I stated in my previous lectures, the European laws for intellectual property protection, it could be trademarks, patents, copyrights, privacy, are all more stringent. So the Copyright Term Extension Act that the Congress approved, enacted in October of 1998, tries to bring the US law in sync with European copyrights law. So copyrights for works created before 1st of January 1978 had a term of 28 years with the option to renew your copyrights for 67 years. Before this particular Copyright Term Extension Act came in, the renewal term was only for 47 years. Now, after the Copyright Term Extension Act was enacted by the Congress in 1998, the term of renewal was extended from 47 years to 67 years. That's what is in bullet number 2, where you see the term of most copyrights was extended by 20 years. So that's the 47 years before the Copyright Term Extension Act came into picture. And that's the 67 years. That's the renewal period that came into effect because of the Copyright Term Extension Act. They increased it by 20 years. Now, copyrights for works created on or after 1st of January 1978 generally endure for a term of consisting the life of the author plus an additional 70 years after the author's death. So anything that happened after 1st of January 1978 as an original piece of work, the author would retain copyrights for the entire life period. Plus, after the author's death, the copyrights would still stay with the author for another 70 years after the author's death. Before the Copyright Term Extension Act came into force and it was enacted in 1998, the term after death was only limited to 50 years. And after the Copyright Term Extension Act came into picture, it was extended by 20 years, and now you see the 70 years. So from 50, before the act came into picture, it's now extended to 70. That again goes back to bullet number 2, which it says it extends the term of most copyrights by 20 years. So in both cases, Renewal period was extended from 47 to 67 years, and time after death where the author still retains the copyrights was extended from 50 to 70 years. In both cases, the extension term was 20 years, thanks to the Copyright Term Extension Act, which was enacted by the Congress in October of 1998. Questions here? Okay, exclusive statutory rights of a copyright owner. As the owner of copyrights for any piece of original work that's in a tangible form, what are your exclusive rights as an owner of a copyright? So if you have an e-business and you're an e-business owner of a federally registered copyright work, then you have exclusive statutory rights to reproduce the copyrighted work, to sell it, to rent it, to lease it, or otherwise even distribute copies of the copyright work to the public. So if I'm the owner of a copyrighted work, I could sell, rent, lease, or even distribute copies of it because I have exclusive ownership. This is an exclusive statutory right that I have as an owner of a copyright. I can also prepare derivative works based on the copyrighted work. I can use this work that I own to create another piece of work from that, and that's what is called as a derivative work. I can also perform, display publicly the copyrighted work. Suppose it's a piece of work, which is like a music or a drama or a pantomime or a choreographic work. I have the full rights to perform, display publicly any of the work that has been copyrighted, and I'm the rightful owner of the copyrights. So this is what we talk as in terms of exclusive statutory rights of any copyright owner. So if I'm the owner and I have exclusive rights to reproduce the copyrighted work, I can sell it, I can rent or lease it, I can make copies and distribute some of these works. I can make derivative works from the copyrighted work. I can perform, display publicly the copyrighted work itself. And that's what is the meaning of exclusive statutory rights. Databases can be subject of copyright registration if the author is creative in selecting and arranging the data and does not merely display the data as facts. So suppose you collected data, a lot of data, and I use that data in a creative way. I can rearrange it, I can reclassify it, I can use your data, but in a very creative, novel way. Then such a database that has been manipulated to be very creative, to be very different, innovative, and it has been rearranged and selected in different ways, then the database can become a subject of copyright registration. So there is a case in the second bullet here. So a federal court in deciding an online case involving a company called Redbook that listed retail value of used automobiles would be granted copyright protection. They are using some data which already exists, but what Redbook did, the listings in the Redbook were found to be original as they included the selection of optional features in a very unique fashion. They made an adjustment for the data of used automobiles for mileages in 5,000 mile increments. So they said, hey, here are cars, used cars, which are between 0 miles to 5,000 miles. And then there are a bunch of used cars which are between 5,000 miles to 10,000 miles. So in increments of 5,000 miles, this is smart because they're rearranging the data, not saying, hey, this is the entire database of used cars. We will rearrange it in increments of 5,000 miles. And today you see that usage in anything, Carvana, whatever website you go to buy used cars, you have data which shows up in 5,000 mile increments. So the first company that did this was Redbook, and they had all the listings of used cars in increments of 5,000 mile usage, and use the concept of an average vehicle as a subject of evaluation. So this is a different way of doing it. And then the federal court said Redbook has the authority for copyright protection because they used whatever available data was there, but they used it in a very creative, different arrangement, different classification. So anything that you do with data that's available in the public domain, but you're smart enough to rearrange it that makes more sense, then you have a chance to copyright protect your new way of doing something. So that is where databases came into picture as a subject matter of copyright registration. So the right to prepare derivative works. I can use my own piece of original work to create other work. So web designers, because you're all into creating new businesses, you want your businesses to be on e-commerce sites, and web presence must be there. So web designers examine different websites and select their most attractive features. We all do that. The designers must be careful not to infringe on the copyright of another site while preparing a derivative work. We're using existing work, we're preparing a derivative work, but we have to be careful as designers that we are not creating something that will infringe the copyright of another website that's already existing. So the Copyright Act defines derivative work as a work based upon one or more pre-existing works, such as a translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art production, abridgment, condensation, or any other form in which a work may be recast, transformed, or adopted. Something like that is called as a derivative work. So you can refer back to something that's existing. You can recast it, transform it. You can adapt it, adopt it in different ways. But you got to be very careful that you're not making an infringement of a piece of work that's already existing or a website design that's already existing. As long as you do that, when I write my research paper, when you guys write your research paper for different courses that you're doing, you're also referring to what's available in Google Scholar, you're referring to what's available in the university library databases, but you make sure that you're not copying per se, you're not just copy pasting it. You write your own thoughts, you make your own flow, you connect the different dots the way you think is very unique and special, but also you make a reference and citations of the work that you have utilized. So you're not infringing on original pieces of work, of authorship, as long as you know that you're making your own contribution, you create it in a different way, in a novel way, you've transformed your ideas into an original piece of work, but then you're also using ideas from already existing websites or authors or articles, and you're transforming this, and you also give the appropriate citations and references. You're not infringing, and then now becomes your piece of work, which is a derivative work, and it can still get copyright protection. The theories of liability for copyright infringement. So there is direct infringement. The direct infringer is the direct actor who, with or without a specific intent to infringe, because see, copyright protection is a strict liability. So even without an intention to infringe, you become the primary party that violates one of the copyright owner's exclusive statutory rights. So you don't have to have an intent to infringe. Even unintentional infringement, innocent way of infringing still becomes an infringement. So the direct infringer is you in this case, because you've infringed, copied somebody's piece of work or a web page or an authorship. You violated somebody's copyright ownership and their rights, exclusive statutory rights. You become a direct infringer. That's what we call as direct infringement. So the Copyright Act is a strict liability statute, as I just mentioned, meaning that knowledge or intent of infringement need to be proved by the plaintiff. And if you say, hey, this person has done an infringement, we can prove it to you, then you will be liable. Contributory infringement. Contributory infringement is that it's like a tort. It's a civil wrong, not based out of contract, of contributing to the direct infringement of another. So there could be two people or two companies which are part of the infringement. One is the direct infringement, and there's a contributing infringement. So a person with knowledge or reason to know something is happening here, an infringing activity is causing or materially contributes to the conduct of the direct infringer, but still I become part, I'm an accomplice. I'm contributing to the direct infringer, knowing very well that there is some infringing activity or material contribution of the direct infringer. I could be held responsible for contributory infringement. For there to be contributory infringement claim, there must be first be an actual infringement. So a direct infringement has to be there by another person, and I could actually help this another person, and then I'll be held responsible for contributory infringement. I mean, the easiest example that I can think of giving you is like how you do teamwork and you're submitting, your research reports as a team. And say one of the team member has plagiarized, and you have this person directly plagiarizing, but then because it's teamwork, you could be held responsible for contributory plagiarism. So this is what we call as contributory infringement. Vicarious infringement occurs when a company receives direct financial benefit from an infringement by another party, and had the right and ability to supervise the infringement activity. So suppose I'm dealing with a company and the company involves an infringement and I get the financial benefit out of it. And I have some ability to supervise this company which indulged in the infringement activity, then I am vicariously liable. So courts then can hold me vicariously liable because, I just have the ability to control or supervise this other company that has indulged in infringement. But I'm the beneficiary, I've got financial benefit, and so I can be accused of vicarious infringement. So therefore, courts have held that vicarious liability requires neither knowledge nor participation in the direct infringement, but I have received, in this case, a financial benefit, and I have the ability to supervise, control the other company that has indulged in direct infringement activity. So if I've received financial benefit, that's enough. I don't have to either know or be aware that an infringement is being done by the other company, but if I've received financial benefits from them, then I can be held vicariously liable, in this case, for infringement. Questions? There are limitations on exclusive rights, on copyright owners' exclusive rights. Fair use doctrine. This is called a statutory limitation on exclusive rights. Because you're the owner, you generally have exclusive rights, but there are limitations on that. And one of the limitation is fair use doctrine. So Congress's position that public interest is best served by placing statutory limitations on the copyright owner's monopoly to its original work. So anything that the Congress feels is in the public interest, they can put a limitation on your exclusive rights of your own piece of work. So exclusive rights will not stay good because there is a fair use doctrine, and that is exercised by the Congress taking the position that public interest comes first, and therefore the copyright owner should not have a monopoly of the original piece of work, and therefore it limits your exclusive rights. Certain fair uses of copyrights are authorized by law and do not require the consent of the copyright owner. So if there is a legislative body or a court that says, hey, these are should be made publicly available, though they belong to a particular copyright owner, then they don't require you to consent because they think it's in the larger interest of the public or the society. And so law can authorize the use or access to a particular piece of original work, and for which they don't have to seek your consent. And this is another case where law determines the accessibility of this particular copyrighted work, and therefore law can limit copyright owners' exclusive rights. The purpose and character of the use, including whether its use is of commercial or educational purpose. I mean, teachers distributing any material that doesn't belong to them is an infringement. So just to let you know, I cannot simply share a book here, a soft copy of a book without taking permission. So that will be an infringement. So what I have done in my slides is read through all the books and materials. I've made my own slides here as I share them with you. I'm not permitted to use a textbook, a soft copy of a textbook, and distribute it just because I think it's good for you. I cannot do that because that will become a clear case of infringement. The nature of the copyright material, factual data, news is not infringement. Suppose I share something that's available in the public domain, anything that's already published. I bring case studies every class to give you a little bit of time to analyze the case and come back and present it to me. Now, if I distribute that kind of information, which is already available in the public domain, that's not infringement. The amount and substantiality of the copyright material in relation to the copyright work as a whole. Now, critical portion may implicate infringement. Suppose I'm just making an indirect remark or a reference to your work, that cannot be claimed as an infringement. But if I take substantial portion of your work, so I use your model, I use your methodology, I use your factors or attributes that you've considered for your research. Now this becomes critical portion, and that might clearly implicate infringement of ownership of copyrights. So just as a casual reference or a remark referring to a piece of work cannot be counted as infringement. The first sale doctrine, this is something that you all should know. The first sale doctrine of the Copyright Act limits the copyright owner's exclusive right to distribute publicly a copy of the work when the copyright material was lawfully acquired by another. So suppose somebody purchases my work by paying me X amount of dollars, and now they become the owners. So I will not have exclusive rights to distribute a copy of the work because this was lawfully acquired by someone else. The owner of a copy. So somebody bought the copyrighted material that initially belonged to me, they bought it. So they become the owner of a copy, is now entitled without the authority of the copyright owner to sell that copy. So because they have rightfully purchased it, now they become the owner of the copy, they can sell it without the authority of the copyright owner. However, the sale, rental, lease of a licensed computer program without permission of the copyright owner may still constitute an infringement. So suppose you've written a piece of code or a software or a program, and if I start using it without your permission, now that definitely becomes an infringement. Public domain materials which are available, as I mentioned before, that are available in public domain are not subject to exclusive statutory rights. So all the data which is published by the US government, records that are out there, court decisions that can go out there, board of regents decisions which are live telecasted, which are out there, and also the work for whose copyright terms have expired. So maybe they're old copyrighted work, but it's more than the term of copyright ownership. Then all such work can be used because they're available in the public domain. So like I can give an example of myself using data which is available in public domain. I don't have to worry, I don't have to take approvals because the work is already available in public domain. I can use that data to do some form of research. What happens in the case of infringement? You have remedies for copyright infringement. So if your website has been copied, if you feel your ownership has been infringed, you can file for monetary damages. You as the complainant or plaintiff may sue for the return of any profits made by the defendant. You can file a case against me because you say, I've copied your web pages and I've made some profits and money out of it. You can file a case against me and ask me to return any profits that I've made by the use of your copyrighted material. So you're the plaintiff in this case, I'm the defendant, and if you have ownership of that particular copyrighted work, including the web pages which I have copied and have infringed your rights, then you can file a case and actually get back all the profits I've made using your copyrighted website design or materials. Now, what are the other statutory damages? Under the Copyright Act, they're set anywhere between $500 to $20,000 per work that has been infringed. So it depends on the nature of work and the extent of the infringement. The fines or the statutory damages that are levied range between $500 to $20,000 per work infringed. Any willful infringement may result in damages up to $100,000. So if you can prove as a plaintiff that I willfully infringed your work, copyrighted work, then I'll be asked to pay damages up to $100,000. Innocent infringement may be reduced to about, a minimum of $200 instead of $500 per infringed work. That's what is there as statutory damages. The Intellectual Property and Communication Omnibus Reform Act, 1999, the statutory damages increased from $750 to $30,000 per infringed work, and a willful infringement was raised from $100,000 to $150,000. So those are the damages that the court and the legal authorities can ask can make me pay if I've infringed on any kind of work. Attorney's fee, suppose you're a complainant, you're plaintiff, and you're filing a legal case against me for infringement, copyright infringement, then the court can order for a reasonable recovery of attorney fee that you might have to pay, and you can recover it from me. So you're filing a case against me, you're the plaintiff, you're filing a case against me because you think I've infringed your copyrights, I've copied your web page design, blah, blah, blah. In that case, you pay an attorney fee as a complainant, and the court can say, you can recover that attorney fee from the defendant, which is me. I'll be required to pay the attorney fee as well. Sometimes, because of the nature of businesses that we are in, you might have a situation where any infringement can lead to irreparable damage. A loss can be huge. So you as a plaintiff can seek for preliminary injunction or a temporary restraining order. So a plaintiff, you as a complainant or a plaintiff in a copyright infringement case can ask the court for a primary injunction or a temporary restraining order. In the event that you anticipate there'll be irreparable harm or damage or loss if you let the infringement continue pending the upcoming trial. So as things are proceeding in the court, you say, hey, you have to stop Prabhakar from using my web page design because it's going to cause irreparable damage. It can damage my reputation, hurt my branding, and therefore you seek to have a preliminary injunction or a temporary restraining order on me so that I don't continue to use material that you think has been infringed as we wait for the decision to be made in the court of law. So pending a trial process and pending an order or a decree from the legal authorities, you as the plaintiff can seek a preliminary injunction or a temporary restraining order preventing me from using what you think is an infringed copyrighted material that you rightfully own. So that's about preliminary injunction and temporary restraining order. Thank you. And if you have questions, please feel free to share them with me. I'll be more than happy to help in resolving your questions.